me a little bit.
Not bad.
So I don't know, I think it came from when they were younger, not setting those expectations of this is what we need you to do.
Well, and I don't know about you guys, but when I think about my upbringing as compared to how I'm raising my kids and the different just times in life, you know? Like life right now is so much busier, and so therefore I feel as if it's moving so fast. If I ask my kids to do it, they won't do it right, and then it'll take twice as much time, you know?
Well, because it's faster and easier and a lot less hassle to just do it yourself.
Exactly. Well, we have several great participants in the room, which I'm so thankful for. Let's see who we've got on Zoom here. Sorry that I started a minute late. I actually came in thinking I was gonna do this 10 minutes early, and then I ended up just logging on a minute late, so sorry about that. So we've got Jenny. Jenny, what's your last name? Jenny I'm thinking of? I feel like Jenny Kisling's
She's a J-E-N-I.
name is usually, spelled a little differently, so.
Jennifer Wilson.
Oh, hi Jennifer, how are you?
Good.
Good, thank you so much for zooming in. I'm not the most tech savvy person here, so give me a minute, I'm gonna share the screen and then you tell me if you can see it, okay? Do you mind speaking up one more time? Can you see this?
Yep. I can certainly see that.
Okay, perfect. Uh-oh, what I couldn't see when I was revising this actually over the weekend is I couldn't see the date on there.
We can't see it either, so.
Okay, good. I originally designed this class and did it last fall. And then in the spring, we, through work of our Agent Leadership Council, put together a position statement on arbitration because we had quite a bit of questions and uncertainty. So our arbitration position is dated in May, and you guys have a copy of the position and also the arbitration form right now. So thank you for coming. I'm guessing there are some specific questions that some of you might have. Is there anything that anyone is dying to know and wants to be sure to cover?
I just wanna know, like, I've never been to an arbitration before, so when I talk about it with my clients, why is it a benefit to them
Yes.
or not?
Perfect, we will cover that, that's perfect. I love people who do have experience or times that they run into it, you know, working or not working. And so please be sure to chime in. But my objectives today are to cover the Keller Williams Preferred Realty premise on why I think this arbitration form is important. I also want to cover the pros and cons of your clients choosing arbitration. I want to talk about the background and the process as to exactly how arbitration works. In the time that I've been a broker here, we've had one arbitration case, and I'll give you a little bit of the background of the case study on it. I'll also give you some resources, and then certainly we will cover your questions. So, let's go on to some statistics about arbitration. Thankfully for Greg Hartos, he was able to share this information with me. On average, in the state of Minnesota, there are about 75 arbitration cases filed related to real estate every year. On average, the dollar amount that is awarded is actually below $20,000. And in 2013, there was an arbitration case where the money that was awarded was $302,000. So it can go really, really high. So if you would pull out the form that has the red KW on the top, this is something that our ALC worked really hard to put together. And the reason we did so is we had an attorney in here talking about arbitration, and he had a little differing opinion than my opinion and Greg Hartos's opinion. And we felt like he scared some of our agents, and we thought, you know, we need to remind them that you, when you came to work for this brokerage, signed an independent contractor agreement. And as an independent contractor, you are entitled to make decisions on your own. You can choose to do things for your business. And we wanted to give guidance and advice to agents, especially brand new agents, whether or not we as a brokerage suggested, yeah, we think you should sign arbitration and we think your client should sign arbitration. What it came down to in the end, what we agreed to as an ALC, is that there are a lot of positives to using arbitration, and the only way it can be used is if all parties involved sign it. If both the buyer's realtor and the seller's realtor and all the buyers and all the sellers sign it. So if you find yourself in a post-closing dispute where your client may wish to use arbitration and then they find out you didn't sign it, when we pull the forms back out, they may say, well, that person wasn't really acting in my best interest because now I've done all this research and I do want to use arbitration. Everyone else agreed to it, but the realtor essentially is like the stumbling block in the case. So we decided to make this position that we said, because it is endorsed by the state of Minnesota, and because we feel you would be eliminating, the option for your client, it is a good idea to sign it. So it's a position, not a policy, because you as an independent contractor can decide to do whatever you wish.
That got me thinking, have you ever seen, like say a buyer submits an offer on your listing and the buyers decline arbitration? Or vice versa or whatever. Have you ever seen it where it gets countered back to the other party saying, hey, we'd like you to actually undecline it?
That's really interesting. I haven't, but I know that Steve Rawl has talked about it once. And so, not to say that it doesn't ever happen, but I think you could include it in the counter if you wanted. Something that is important to remember is from a compliance perspective at KWPR, I require, and through One Team Compliance, I require that every single party has signed or declined it. So if the offer comes in and you're representing the seller and the buyer didn't sign it, well, that probably means they declined it and just, clicked decline in Authentisign. And then it goes over to you and you say, well, if they didn't agree to it, then we don't even need to sign it. So I'm not gonna set this up for formatting for my seller. And then you turn that form into compliance. From an outside perspective, and I didn't know the background and we didn't know the situation, it almost appears that neither the buyer or the seller was offered the right to arbitrate. And we just want it to be crystal clear. They were given the option and they write declined, or they were given the option and they write signed. So if you ever get it back from a compliance, return to agent, it's likely just because you didn't put the proper information on there. I am okay with if you email your client and say, oh, you know what, you probably pressed declined when we do this electronic signing process. Do you give me permission on your behalf to write declined through here? And if you have that email as a backup with them saying, yeah, let's just keep it simple, go ahead and do that. You'll also run into a lot of stubborn other realtors who say, well, this is idiotic, you're making me take this whole extra step. And if you just have the backup email to them as well, explaining why their side didn't, I just really want the background. I really want the verification that everyone indeed did have the option to consider it. So that is why it's important to me, and that's why we developed a position around it. And like with all of the policies, and really this is our only position statement, you can always find these on KWPR-dashboard, but you have a copy here for yourselves if you want to keep it. So here's the whole premise of arbitration. It is for post-closing disputes that relate to failure to disclose of material fact. So like I already explained, it really must be signed by all parties or written decline so that we understand that they were even given an option. And then if they all agree to arbitration, this form right here determines how the dispute would be handled should it come up after closing. And it's really, really important that you recognize what this means here. So when you're now looking at the actual arbitration form, and I would just encourage you as your homework, as you're trying to fall asleep at night, pull this out and then you can crumple it up and throw it in the recycling bin. But read it line by line because it really does give a lot of good information. And this is one of the forms changes as of August 1st. We just didn't highlight a lot on it because there were so many new things to cover. But you can almost kind of look at this in three ways. If they sign the arbitration form, that means they would agree to handle a dispute that's below $20,000 in conciliation court. Or if they get bids and they find out it's above $20,000, then they have to go through arbitration. They waive their right to go to court, as it says here, but they don't waive their right to go to conciliation court. So it's almost like they waive their right to file a lawsuit. You know, they can file a small claim, but they waive their right to file a lawsuit because they've pre-said ahead of time, we all agree going through arbitration is a good idea and a good option. And it used to be $15,000 and it's now $20,000. So that's the change on the August 1st form. It's also been changed on the bottom, the website that they go to get information on this, and that was just a really small grammatical change, kind of a little bit earlier in the year.
So I have a question,
Yes,
not to interrupt you, but if you don't mind.
no problem.
So you said that 20,000 is the limit if they all sign.
Yep.
But then you said that there was a case that was over 300,000. So
Yes,
your clients, because I think that's the biggest concern for people is, well, what if it's something bigger that wasn't disclosed?
yeah.
So they could still get above the 20,000 in conciliation court. But that's what I mean, so how does that work? How am I
Actually, I
confused? So
probably
what did I
will have
miss?
to look into that because, so here's what would happen if your clients, you know, you represented the buyer, they move in, they found out there's a leak in the roof. They'll call you. That'll be the first call they'll make. But what they really should be doing is they should be calling for estimates. So they call and they get estimates and they find out, you know, okay, it's gonna cost $10,000 to redo the roof, it's gonna cost me $5,000 to redo the sheetrock, and it's gonna cost me $2,000 to redo the flooring in this particular area. What they would learn from having those bids is that they must go through conciliation court for that. They cannot file an arbitration claim because it hasn't yet met the $20,000. Now, I don't know if it's an intermix, like if they go to conciliation court and then they learn like, oh, this is so much more damage, this is so much more money, you have to go on to the next step. Go ahead, Misha.
What is conciliation court?
A small claims court at the county courthouse.
Well, I've been to small claims, but we call it small claims.
Yes.
Well, it's conciliation now.
I hate Minnesota.
Well, you know, there's gotta be a lot.
Okay, so
Political
conciliation is just
correctness.
small claims.
Conciliation court is small claims court.
20,000 is no longer small.
Well,
Right, maybe that's the way to think about it.
Okay,
Yeah.
okay,
Yeah, good point.
that threw me. I was like, what, I don't, what?
So Sherry, I can't technically answer your question, I can look into it, but I think, well, maybe you can tell us since you've been to conciliation court. If you take something to conciliation court, could the judge or the other parties ever say like, oh, no, actually, you're entitled to way more than $20,000? I think you have to go in saying, this is what I've learned, this is how much I've already spent in repairing my house, I'm mad at the seller, you owe me this $18,000.
Ours was over earnest money, so
Okay,
it wasn't about hidden anything.
sure.
So
But I
don't know.
think what your buyer, you know, the one who's likely gonna be filing this claim, what your buyer is going to say is, I've gotten all these estimates, it's $40,000, I can't go to small claims court because that's only $20,000 and less. I did sign the arbitration form, I have to go to arbitration and maybe I'll get awarded way more than the $40,000 through this arbitrator. Or if they declined arbitration, then they say, okay, I can't go to small claims court, now I have to hire an attorney and we have to file a lawsuit.
So if it's, so I guess you did just answer my question though. So if it's less than 20,000, they have to go to conciliation
Yes.
before arbitration.
Yes.
But if it's over, they cancels conciliation and they automatically go to arbitration.
Yep, and cancels, you know, hiring an attorney and filing a suit.
Right, but you can bring
Because-
an attorney to arbitration, but.
You can,
Yeah.
yes, you can.
Okay, so I'm just reiterating.
Yeah.
So less than 20,000, you go to conciliation, which is also known previously as small claims. Ours
Yes,
formerly
yep.
known as small claims. Okay. Now, if it's more than 20, so if it's $20,500, we have to go to arbitration. But if we sign this arbitration paper, we can't go to real court.
Correct. I think
But
you
if I don't
summarized
sign
it
this
well.
paper, we can go to real court.
That's right.
Or you could still choose arbitration, right, or no?
No, all parties have to have agreed to it.
That's okay.
Now, you could go back to the parties and say, I've got this problem, would you sign the form now? But it's, you know, it's unlikely or uncertain that they would.
I'll ask my question after.
I think you can go ahead.
So why would we go to arbitration, not court?
Well, there you go. We're at that spot.
You're welcome for the segue.
Thank you very much. Any questions though about our position or about the form itself? I do want to note a change that I think I saw on the form is on the back side. It's asking for the date of the, it's asking for the property address and the date of the purchase agreement. Did it always ask for the date of the purchase agreement? I'm not sure I ever filled that in before. I feel like the date is new. I think the property address has always been there and all the citing blanks are the same. But I feel like date is new and I could be wrong on that. But don't miss that as you're going through your forms or we'll send it back for compliance, sadly. Okay, so on the front of the arbitration form, it talks about how you can go to this website here, the National Center for Dispute something. And it is a good website to look at, and I have it as resources at the end, so you guys can take a picture of the slide or, pull it up on your phone right now if you want to. But it is found to be a less expensive and more hands-on personal way of really looking at the problem of the house. So we'll use the same example. Your buyer has found out that they have a leak in the roof. They're very upset, there's mold in the roof, they're just certain that leak has been there forever and they've just been painting over that corner of the closet or whatever. And so they're saying, they call you and they say, I am so mad, like this, the sellers knew this. They've been painting over this, the mold's been building up for years. Take care of this for me. And the very first thing that you would do is you would go to command and you would pull out all of their documents and you would look to see if they signed agreement of arbitration. And you would remind them then what you probably reminded them at the time that you went over the form to have them either agree or decline, is that you are not an attorney, you cannot give legal advice. You can't really even tell them whether most people agree to arbitration or not, but sometimes I allude to that and I say it is commonly agreed to at my brokerage. We even have a position that our brokerage suggests we sign it to agree to this. It is less formal and it's not as complicated as litigation. It's decided by a private citizen, not a judge. It is generally less expensive to do than hiring an attorney and wading through and going through all these court dates. There's also some things, if you've ever been in a lawsuit, and I really haven't, so I can't speak to these like real personally, but it also requires that discovery of documents is limited, whereas if you were to file a court case, attorneys could say something along the lines of, I demand all these documents. So it's a little less almost kind of intrusive and things are requested, but they're not demanded, and that's in discovery. The final decision of arbitration is binding, so that can be kind of a pro and a con, because if your client found that they weren't pleased with what the judge ruled in a court case, they could appeal that, and in arbitration you cannot appeal it. These things are usually a lot quicker because decisions for arbitration are usually scheduled within like 90 to 100 days, and these court cases could be assigned a hearing date out, 6 months down the road. A party can participate in choosing the arbitrator, where you can't technically choose your judge, but you could hire attorneys. So this form is this pro and con list was not updated by the Center for Dispute Resolution or the State Association after August 1st, but it reminds us that you do give up your right, and I don't like go to court, but it does give up your right to hire an attorney and file a lawsuit for claims over $20,000. You give up your right to have a judge and jury, which is, if you really want a jury to hear this, you give up your right to a jury, you're only in front of an arbitrator. You give up access to the traditional court process. And like I said, the pro and con of discovery of documents is limited. So if you really want to force discovery of documents, if you're saying as the buyer, you're saying, I know that they had safe basements in here because the neighbor told me that they were over with their work truck and they were doing something on this foundation or whatever, you give up your right to formal discovery, which would force those things, and you also give up your right to appeal.
Melissa,
Yes.
you mentioned, you can go back to the pro con.
Yeah.
Under cons, you said that they give up their right to court and an attorney, but they can still have an attorney in arbitration, I thought you said.
I'm sorry if I said an attorney, they absolutely can hire an attorney to represent them. I maybe meant to say jury.
Okay.
But yes, that's a very valuable clarification. they can have an attorney represent them in arbitration.
Oh, I'm sorry, I have one more question.
No problem.
I heard, or I was told when I first was learning real estate,
Yeah.
that the arbitrator is a licensed residential arbitrator. Is that the case? They are licensed, they know, I mean, so it's, because the way you have it written there, and I'm not saying it's wrong, or wherever,
On this
wherever
one?
I saw, yeah, that it's a private citizen, it makes it sound like, you know, just some third-party Joe off the street or something, so I just wanted to confirm.
Yeah, that's a
that
really
the
good
case.
question. I haven't dug into that detail on the National Center for Disputes website, but I think this was provided by the State Association and the Center for Dispute. And I think what they're probably implying here is it's not someone who's gone to law school
That
and
makes sense.
been appointed a judge and all of those things. They're kind of more of a, you know, maybe they have experience in
Okay,
home
that makes sense.
inspection.
I just wanted to make sure for in my mind, that they are a licensed,
They are.
you know, residential, you know,
They
arbitrator.
absolutely are. Yes, indeed.
Melissa, I have a question.
Yeah.
What is the difference between arbitration and mediation?
Arbitration
One and the
is
same.
what?
Mediation is not final, arbitration is final.
Okay.
Arbitration is legal and binding.
Yeah.
And mediation
Is
is, you
not.
can still go to court
Kind of
if
like
you get mediated.
discussion, maybe?
You can get the heck out of there if you're mad at them.
Yeah, you can leave.
Okay.
It's not binding, nothing in mediation is binding.
And I asked that in my previous state, we did mediation, there was never any discussion of arbitration, so I
Oh.
didn't know. Like, we had the people, I don't even know if we had them sign a mediation form, maybe we did. But we would do mediation before going to court because it was less expensive, yada, 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 yada.
Yeah.
So, I guess there it took the place of arbitration.
Yeah,
But arbitration is legally
Binding.
binding and whatever they say, you stuck with.
yeah,
Yeah,
that's good,
okay,
that's a really
that's
good
good.
clarification.
Thank you.
Okay, so here's what I really want you to know in your daily practical involvement, because I feel like this is almost the number one thing that comes up. A very unhappy buyer calls you, and they call you because you kept them on a smart plan and you invited them to Santa, and they think they've got you as a realtor for life.
They
But
do.
the reality is your representation, and it's risky to the brokerage if you pretend to represent them post-closing, your representation ended on the date of closing. So you have to be really, really careful what you say when they contact you all worked up about whatever's wrong in their house. And what Greg Hartos has coached me on, and now the advice that I always give is, I am so sorry you are going through this. I will help you as best as I can. And I need to let you know, our contract ended on the date of closing. You need to make that clear to them. My brokerage and I will do everything we can to help you, but you need to understand our contractual representation ended on the date of closing. One of the things that I can do to help you is I can suggest to you that you go out and you get this work done right away. Don't like hold off on getting the work done, because if you've got water coming in your roof, you need to get it done. And then you'll be collecting the bills, and I just wanna set the expectation that we can't force the seller to hire and pay for all this work to be done for you. You need to get the work done, you need to pay for it, and then you'll have to handle how it is paid for later. I can send you, as your former realtor, I can send you copies of all the paperwork and all the documentation that we signed, but that's really about it. I can't refer you to attorneys per se, I can't refer you to contractors to do the work, because if something goes wrong with either of those, they really could bring it back on you, and you've then given them advice and you don't represent them.
Could you give them a list of contractors?
Yeah.
Okay.
Yeah,
But
absolutely.
you just can't say use this, or it's not smart to say use this.
Yeah, I mean, I think it would be smart to try to not give them anything.
Got it, okay.
But if you wanna have a list prepared and ready, you know, that seems like a reasonable item that a realtor would do, in my opinion. Yeah,
What is a realtor's responsibility in providing those documents? And assuming like over the course of time that they maybe have changed brokerages, so like Maria, who did a lot of transactions with her previous brokerage, one of those clients comes back now, is she responsible, or is the brokerage that she is at responsible?
that's a really good question.
Okay.
So it
Well,
gets
my
even more
guess would be my
complicated for you.
contract has ended, but the contract is with the brokerage.
Exactly, yeah, so, they should be reminded, that's a good one, that the contract was with Berkshire Hathaway, not with Keller Williams. So if there ever were like a, you know, a real estate company named in something, a lawsuit or an arbitration, it would be the brokerage that the realtor was at the time of the, you know, time of the closing.
Is that because, is any of this covered under E&O?
Mhm.
Okay, that's
Yeah.
what I was, so it depends on what your broker's, policy was at the time, right?
Yeah, exactly.
Okay.
Okay,
I have a question.
yeah.
So on this form on line 30 to 32, it says, the request for arbitration must be filed within 24 months of closing.
Yeah.
So if something happens after that, arbitration is now off the table, they'd have to go to court? And is
That's
it gonna
right.
be tough to probably prove something that long after the
Exactly.
transfer?
Okay. To follow up with Lisa, that's regardless of the amount after 24
Yes.
months? Okay.
Yeah, exactly. Yes, so they've called you, you said, gosh, I'm really sorry you're going through it, get some estimates right now, we need to know how much we're talking about, I'll send you the purchase agreements, but I need to remind you, I'm not an attorney, and my brokerages and myself's responsibility to you ended on the day of closing. Responsibility might not be the right word, but you know where I'm going.
Softer, Melissa, softer.
You'll choose the smooth version when you talk with them. So we also then will tell you, it's a good idea to, when you send over the copies of their purchase agreement, to say, hey, would it be okay, I will reach out to the other realtor, just let them know that this is going on. Would it be okay if I shared your name and phone number and also collected the seller's name and phone number? And if, they've already gotten that, which does, I feel like, seem to happen a lot, all the better, then you just need to remind them, you as the seller and the buyer need to work this out on your own. Us realtors can't do it for you. We don't have a legal team that's on staff to do this for you. It's really best to try to put them together. So most often, the buyer and seller won't be able to come to a resolution. Your buyer is going to keep calling you. They're going to continue to be frustrated. But that's why it makes sense to turn to an impartial outside entity. And while taking these, troubling instances to court, it is also found, and this is why the Minnesota Association of Realtors endorses it, is also found that arbitration does offer a faster, I copied their words, cheaper alternative that can save all parties a lot of time, money, and aggravation. So you can't give any legal advice, this can only be done within 2 years after closing, and there is a filing fee for it.
So the filing fee is for arbitration.
Correct.
So like mediation, it's a certain period of time or a certain number of hours or whatever, and that includes everything?
Well, actually, go to the website, it's pretty fascinating. It's a sliding scale, and so I can't really even give you an exact number. It's kind of surprising how much it costs to file an arbitration claim. I mean, it starts at like $1,500, and it goes up a lot more. And I maybe should do a screenshot next time of the actual sliding scale. But they're gonna find, if it is a major problem, that it's not as cheap as it says on the state website.
Well, I think that's where it's misleading, because the filing fee at the county is what, $45 or maybe
Yeah, that's
under
what we were just saying.
Mm-hmm.
$100.
You were just saying that, like,
So
For
the-
small claims court,
Right,
conciliation, Melissa.
affiliation court.
so it's considerably less.
Yeah.
So when you're talking about costs, you do have to kind of, just so you know, in the long run, this may be less expensive for you to take, but it's the time off and going to court, hiring an attorney and everything else, but this is not inexpensive at all.
Well, you still have to go to conciliation.
If it's under 20,000.
Yeah.
Yes. So something from the case study that I was exposed to, I wasn't really even a part of it, but something that I think could be a huge advantage to arbitration is that these hearings are usually held at the property. And they're also held fairly quickly within filing. You as the agent may be called, but not necessarily to the case. It is the arbitrator's decision whether they're gonna call the real estate brokerage or the agent. And that information isn't shared with us because we're not a part of the transaction anymore. So if your client says, okay, I filed an arbitration claim, let me know if you or your broker hear from the arbitrator, like pass it on to me, because I'm not automatically being informed of it. And it may go on and you may not even be called, you may not even know about it. Sometimes they tell me the arbitrator decides virtually right there, like this is very cut and dry, I'm looking at the problem, this is, how I'm resolving it today. And at the absolute latest, their decision must be rendered no later than 30 days from the date of the closing of the hearing. All decisions are final and binding, they're permanently settled, and there are apparently a few reasons an arbitration award could be overturned, but very unlikely. It's a relatively informal process, so, you may even want to mention this to your client as they're deciding to sign arbitration or not. There may be some styles of personality where you say, I think this might be a little too informal for you. Like, you should really think about how formal you want this process to be. And then for others, you may say, gosh, this is very casual and it seems like that may be comfortable to you should a post-closing dispute arise. Let's see here, so I just reiterated the $20,000 thing here. So any damages for $20,000 or less must be resolved in conciliation. Also known as small claims court, right there, Misha. Known as small claims court, there you have it. So I'll tell you just really quickly about the case study here. So we represented a buyer who bought a house it was like end of 2020. People were making offers on things without home inspections, and they went to change out the mirror in their half bath, and they found that there had been work done behind there and the wall was never patched. So that immediately put the buyer on like, oh my gosh, what else in this house is wrong? And it turned out there were a whole bunch of things wrong. And one of the largest things is they had done an addition on the back of the house that went into like a pretty serious drop off. And they didn't get a permit for the addition, and they didn't do proper structural foundational support of the ground around it. They were using these bags of mulch, and they stuffed them in and then did a keystone retaining wall behind it. So it was serious. And there's a woman on HHG, she talks pretty openly about this, so if you want to hear more personally about it, talk with me, I'll connect you with her. And she was really nervous because this was a good friend. It was a good friend of her mom's. Did you want to mention something? So she was called to the case, I was not. And her client, I should have maybe had her remind me of this. I think her client did choose to have an attorney represent them in arbitration, so there was an attorney there. She had to be there. I gave her the advice, just only speak when spoken to, don't elaborate, don't give a lot more details. And so they didn't have a lot of questions for her. It really didn't boil down to, did the attorney, this wasn't a file or a claim against her. This wasn't, did the realtor fail to disclose? This was all about, did the seller fail to disclose? So it's hearing a buyer and a seller. It's not putting the realtors on trial in that instance.
Can I ask, so you said it's not a fail to disclose because obviously there's nothing she could have disclosed, but can a realtor be found to, oh, you should have known this, you should have seen this, and obviously not necessarily in this case, but
Not
I mean,
in arbitration.
okay, so so it's not about you, it's always all about just disclosure, it's
Yeah.
not.
I will say with a caveat that because I haven't had enough experience in it and because I'm not an expert in law with a legal degree, business law was my least favorite class in college. Sure, didn't know that was really gonna come back into play 25 years later, but to my understanding, no. It is not a hearing against you, it is a hearing 100% against the other party. Maria, do you have any experience with that?
Knock on wood, no. Thank goodness. And it always does come down to, you get a call from your buyer and they complain about something and you try to get them connected. And usually you call the agent and you work it out. I mean, in every incident that I've ever had, we've just worked it out to the satisfaction. But with arbitration, I'm wondering though, if because it's based on material facts and non-disclosure, I mean, it certainly could come up that the agent could be liable if there was something that you were told and chose to not disclose it also. I feel like that there may be a piece in there that you may get pulled in on that if through some of that, because the neighbors always talk. Well, the agent was out there with them looking at the foundation, how did they not know that also? So I think if you know a material fact, I mean, we talk about this all the time in our professional standards. If you've been told a material fact about the house, you owe it to disclose it, regardless of what your client says you should or shouldn't do for them.
Yeah, and not on the agenda, but I'll mention amending your property disclosure is really important. I'll come back to that, but
I think you're absolutely right, but I don't think that has anything to do with the arbitration.
Okay,
I think it could be like a secondary thing as a result.
Yes,
okay.
because the arbitration is, you have a problem, you have a problem, let's figure out what the answer of the problem is, not the cause, not the, it very
It could
little.
just spill over into something farther.
Later on, you know what I mean, yeah, it absolutely, the response may be, hey, I'm gonna report you to the Professional Standards Committee for the
Department of
fact that
Commerce.
you didn't know and all that stuff.
Yeah.
But the arbitration hearing itself is, what is the problem, what do we know, who knew it, and when did they know it? And I don't see that being really part of it.
Yeah, that's my understanding of it as well. The point that I wanted to make is I really don't feel like that amendment to property disclosure gets used enough, and it is such a valuable one-page document. So whether you represented the buyer or the seller, if there was something that was found during the home inspection that you gained knowledge of or felt was significant enough, you should be pushing to ask the seller to amend their disclosure. Now, you obviously can't originate it if you're the buyer, but you could put in writing in an email, now that I have knowledge of this material fact, I would like to clearly disclose it, and doing that in the email is just enough disclosure to cover your own tail. But really, sellers, I would like to see more of them amending their disclosure. The furnace was found to have a failed starter. It was replaced on September 15th, 2024. That's all, simple and easy as that. Oftentimes less is more is better.
So Melissa, on that, if we represent the buyer and they're backing out because of that furnace they found on the inspection, you're not saying that we have to disclose that because like our buyer's backing out, is that so?
No, I mean Marie, hopefully you can help me here because I feel like we're talking maybe about three things at once. So you do not have to tell the seller why your buyer is backing out on the home inspection. And you do not need to, tell the world unless you bring another buyer back there.
Right.
And if you bring another buyer back there, you have to disclose that.
I just got confused with that, you have to send an email thing. I'm like, well, what's that for? Like,
Well, let's just say your buyer didn't back out. But you know that all this work was done on the property and the seller is refusing to amend their disclosure. It'd be a good idea to put it in paper, in writing somewhere, that you had knowledge of this material fact and you're just acknowledging it.
to my buyer or to the seller?
To your buyer.
Oh, okay, I didn't do the seller, okay.
Yeah, just your buyer.
Okay, gotcha.
Because that's the one who would raise a concern about, who had knowledge of this material fact. And I don't know that it hurts to also tell the seller, if it's something that you and the seller have already discussed. If it was never discussed and you handled it with a price reduction rather than a repair, if you've already talked with them and said, we're putting out an amendment, we'd like you to repair this, then you could email your buyer and also the seller's agent and just say, let it be known, these material facts were discovered during the inspection period, I have knowledge of that. Do you have anything to add there?
I think disclose. If there's an issue with the property, you need to make it known. It is tough when you're working with the buyer and they back out, because a lot of times you wanna go and put the sign in the front yard and say, this house sucks.
Yeah.
But, that's, again, it comes down to, that's the opinion of the attorney that your client hired.
Inspector, yes.
Inspector, correct, not attorney, inspector. So it becomes an opinion, and a lot of sellers will argue that all day long. Well, I'll get my own inspector to counter that. So you can get into kind of some ugly stuff that way, but it is always disclosed.
Yeah, so there are really good resources, actually. The Minnesota Guide to Arbitration through the state website is really good. The National Center for Dispute Settlement, that's what the S means, is ncdsusa.org. And there is a specific form to the, specific link to the Minnesota submission form, and it looks a little bit like this. It says, send the total number of copies based on the selections below, and then you need to send the completed demand form. You need to send any evidence, you need to send the purchase agreement and all addendums, the arbitration disclosure, and also, if applicable, a full inspection report. And you need to send those documents to this location in Texas. And this is what the, this is what the form looks like. Apparently they've changed it since October, I didn't check that. Here we go, this is the National Center for Disputes. Then you go down to, I'm sure you guys wanna walk through this with me, but you go to real property home disputes. Then you go down to Minnesota, there are several other states that utilize this. And then you go to submission agreement form, submission arbitration form. And this is what the form looks like for the state of Minnesota. You just put your buyer's names, if they're gonna have an attorney, what their name is, what the home seller's name is. You'd probably leave the attorney blank because you wouldn't likely know that. You list out both realtors, and then it's as simple as talking about what the dispute is, what your buyer wants them to do as a remedy, how much that'll cost,
Is
because
this
they've
something,
got those
Melissa, that we
estimates.
should be filling out?
No, no, no,
Okay,
no.
that's what I was gonna say, I'm like, we don't wanna be, you know,
No, no, no.
yeah,
They
okay.
fill it all out. But if you've given them this link, that is about as helpful as you can be.
Okay.
And you can give them this link, or call their attention to it on their arbitration form when you send them the arbitration form. And then it's the claimants, so the new buyers of the house would fill it out, and then it tells them that same collection of documents that they need. And so you'd be saying, this is the form that you should fill out, here's a copy of your purchase agreement, have you gotten all of those estimates? So in conclusion, your homework is just read this front to back. It actually is a good refresher and reminder, it gives a lot of clarity. Keller Williams Preferred Realty, as well as the Minnesota Association of Realtors, does see value to your buyers signing and agreeing to this. But if they don't agree to it, that's okay, that's their prerogative. And then just the very last detail now is that it's been changed from $15,000 to $20,000. What other questions do you have?
I don't have a question, this isn't a question, but when I explain to sellers about the seller's disclosure, I explain to them, be as complete as possible, because for 2 years after closing, if there's an issue that the buyer finds that they think you know about, you know, knew about but didn't disclose, you know, for 2 years, this could come back to haunt you. So I don't know if it makes any difference in what my sellers disclose, but I feel like I'm doing a better job by explaining that to them and why it's important to disclose all that stuff.
That is really wise, I love that.
I just had an interesting thing that I saw on the other page, and I just looked it up because I was like, wait a minute, there's a separate form for Edina Realty.
Yeah,
So if there was an Edina Realtor on the other side of the transaction, would your client need to use that instead? Or how, I mean, it is a little bit different of a,
yeah, to be honest, I haven't looked through
the
here.
form is different, it has different things on it.
Yeah, I guess I don't know.
But
That-
I'm just curious why,
That's a Dan Berkshire company.
why, well, yeah,
Exactly.
but why would it not be a state thing? Why would it be a real estate brokerage?
Yeah, I don't know, I can ask about it, that's
Just
actually a
curious.
really good question. Here is that fee schedule though.
Okay.
For claims from, well, they might need to update this too, because this is live on their website, from $15,000 to $25,000, it's a $1,500 filing fee. And then it goes all the way down here if you want a 3-member panel rather than a simple arbitrator. If there are 2 parties and the 3-party claims and it's over $100,000 worth of damage, it's $6,500 you have to pay to file it.
Do you know, has there ever been, and I guess I don't expect you to know this answer, a decision where the arbitrator has said, okay, this is what's happening, and you're paying their $6,500 filing fee.
It probably
is it
does
possible to
state
get
in here, yeah, it probably
Okay.
does state in here, and I don't know the answer to that. I'm not taking good notes, so if there's something I don't get back to you on, remind me.
And that's just really more of a, I wonder if that could be,
Here's some frequently asked questions.
Cause like in conciliation, you can ask for the other person to pay your fees,
yeah,
right?
yeah.
Do I need an attorney? How does arbitration work? How is the arbitrator selected? NCDS will submit all parties an identical list containing an odd number of names chosen from our neutral panel members located in the state of Minnesota. Any party may strike any name from the list and rank the others in order of their preference. They will appoint an arbitrator based on the common preference as indicated by the parties. Under extraordinary circumstances, NCDS may assign an arbitrator, and this is described in the rules. So I would be curious to know your question, who are these arbitrators?
Yeah, how do you pick? I mean, if you got a list of, 5 or 7 people or whatever, I mean, Google them, you know what I mean? It's just,
Yeah. It's kinda like picking a mediator, it's the same idea, you wanna look at their case history probably. I don't know if it's,
Qualification of arbitrators. No person shall serve as an arbitrator in any arbitration which the person has any financial interest. A person is appointed that they'll disclose that they're impartial. It doesn't say what qualifications they have to be an arbitrator.
I always thought the arbitrator was supposed to be somebody that was more of an expertise in that field, so.
That's how I've described it as well,
Yeah.
you know, someone who has an expertise and experience in construction. This is kind of interesting too, it says, all persons who are parties to the arbitration agreement as well as representatives are entitled to attend hearings. Parties are entitled to have witnesses and with proper notice. The arbitrator shall determine whether any other person may attend the hearing. So they determined that the other realtor of KWPR could attend, but I could not. They told me not to come. Yeah, this isn't actually too many pages, so this might be worth reading if you really want to immerse yourself in it as well. Well, I hope that's helpful. I hope it gives you a little more background, and I really appreciate you guys being here.
So let me just clarify this for my sake. At Keller Williams Preferred would like us as agents to sign arbitration regardless of any other party signing it or not. That's always been my position.
Yes.
And when my buyers or my sellers have said, well, you signed it, should I sign it? And I always say, I need you to make an independent decision for yourself
Yes.
on it. And I usually pass it off and say, it's part of my heirs and admissions insurance, because they would much rather us do an arbitration than
Yes.
it would be for that. Is that
That's a
fair to
great
say that?
suggestion. Very fair.
Okay.
Yes, absolutely. And then we, when, you know, you weigh this on your conscience, are telling you, you're an independent contractor, you can choose to sign it or not sign it, completely your decision.
So why are some agents so against signing it? Because they feel we're vulnerable if we do, based on what that attorney said.
I know, right? I don't know why so many people are afraid of it. Can you speak to that from being in the ALC meeting?
all I recall is the, people talking about how that guy scared the crap out of him, and then all of a sudden we're like, well, shoot, maybe we should, but no, I don't recall the exact reasons he gave or anything like that.
I mean, because if you messed up, you're gonna get sued one way or another. I mean, signing arbitration
One of the
is not gonna.
challenges with arbitration doesn't allow for discovery of documents. So, I mean, you're not privy to anything that they have or in a court of law. You know, they're required to produce all the information, and if they don't, that can be, I mean, you have grounds to go back and reappeal that, but you don't have the ability to know what they have or what they don't have, and they don't have to produce it. So, I mean, if you're in a tough spot and we didn't know about that, I mean, you have to somehow prove that they did without anything. But whereas in a court of law, you can say, you legally have to produce these documents.
Like email exchanges or former,
Right.
text messages.
Or bills and records that exist. And if you can't get it from them, you can always go to the people who did it, you know what I mean? But in an arbitration case, you can't go to the person who built that wall and say, you need to come and tell us what you knew. You can't, that's not part of the deal. So, it just, legally, it's just it's a whole different arena. But that's why you pay a lawyer lots and lots and lots of money versus arbitration, which is designed to solve the dispute.
And I think the largest misconception is that you can get in trouble in arbitration. And I don't wanna stand up here and say you can't, because who knows? But another great point that you made, it is not about what you did or didn't do. It's about the condition of the property and the seller and the resulting, impacts to the buyer, not how the realtors were involved in it. That's not what arbitration is for. And we kind of concluded that he, as an attorney, wants everyone to utilize the area of expertise that he has and call him rather than go through something like this. Almost as a marketing tactic.
I mean, you, as a realtor, you much prefer that you represent the client rather than have them represent themselves.
Sure. Yeah, it's not that different.
There's a lot of value in that, but, for arbitration is kind of the same thing, where you're not hiring an attorney, you're just representing yourself, and you don't typically know all the ins and outs.
From a practical standpoint, what's everybody's, how do you can't give legal advice, but how do you guys advise your sellers versus your buyers on this?
I basically have the same spiel for both, and I just say, if something is found, that you feel like the seller had to have known about and you want to have this fixed, if you go the route of arbitration, it's less expensive, and then I say, it's not cheap, it's not free, but it's less expensive. You have a licensed residential arbitrator go to the house and take a look at the issue, versus like taking someone to court and then you're in a courtroom with a judge who may or may not know anything
Who had
about.
family court in the morning,
Yeah,
traffic
exactly.
court, and
Right.
now dealing with a
And
wet
I said,
basement.
but I'll say, it's up to you if you want to agree to that. And that's why I keep coming to these classes, because this is definitely one of the things I feel least, I don't feel uncomfortable with it, but I feel like I'm least comfortable with it of all of the documents or anything like that. And I just wanna make sure, I probably need to do a better job of being a little bit more down the middle of it, cause I do feel like maybe I am, the way that I give the information, maybe I do sway them one way or the other. But I do, tell them that you don't have to agree to arbitration.
I know, Melissa's gonna holler at me afterwards, I know in my past, and maybe I'll change this now, I've always suggested to buyers to decline arbitration because I don't like them to give up their rights. Because once you sign it, you can't choose to do anything other than that, and you only have 24 months to file that claim. So my thought has always been, I don't want you to give up your rights, I want you to have as many as you can possibly have.
Yeah, I'm
So-
not upset about that at all.
Okay.
Yeah.
I
no,
would
that's-
ask you, if they decline arbitration, does that mean that they cannot arbitrate?
You can still arbitrate only if you get all the parties to agree to it.
Okay.
So you'd have,
You'd have
everyone's
to
arguing.
go back to everybody and go,
And
hey,
you have
I've got this problem, I'd like to take you to arbitration, will you sign this, please?
Otherwise, we're going to court.
Yeah.
So I
Yeah,
mean,
so
that's
maybe they
not
would, yeah.
necessarily
Yeah.
a bad discussion.
Yeah, right.
The other thing that you can do in court is you can sue for additional damages. you know what I mean? Where-
Emotional distress and all
Things
of
like
that
that.
stuff, yes.
Well, cornball, but I mean, on the other side, I mean, in arbitration, again, it's about solving the problem, it's not about punishment. And for a lot of people, punishment is super important. Psychologically, if nothing else, or some sort of, reparations for their own situation, where again,
Summary.
arbitration is solely about solving the problem. This was a problem, this is the result of the problem, you're responsible for it, so pay for it.
And only that damage, not
Yes.
additional things.
Yes.
Yeah.
Like loss of work or time,
Right.
whatever.
Emotional
Distress.
So in the event you go to arbitration and the arbitrator awards the buyer X amount of dollars, how do they get payment? Do they have to file a judgment if they never get paid?
Yeah.
So it sounds like what I just heard is you have more options if you decline arbitration. Cause you could go back and say, hey, we wanna arbitrate.
You do, but if you both agree to it, it's certainly simpler, and again, this is simpler, time saving, less effective. If you are more, just more
Arrowed in.
right, that I'd rather have experts involved, and I'd rather just deal with the problem and get it solved. Because at the end of the day, I'm not gonna spend 2 years in court. And if you're, if you go to court, you can drag this thing out.
Well, and that was the
Forever.
case during, especially during COVID. I
Yes.
mean, you couldn't even get a court date.
Yes.
So you could have been, 6 months to 2 years out before it was even addressed. And at least arbitration, it's done very quickly.
Yes.
Right, and that's not including the other lawyer playing games to extend it.
Well, and I think too about like, this is just being very honest, but let's say you're a first-time home buyer using a VA loan, bought a $250,000 townhouse from an investor who owns 100 townhomes. And they didn't sign arbitration, and your buyer says, I'm gonna ask them if they'd be willing to arbitrate now. That seller's gonna be like, no, show me the money, hire your attorney. And then your poor, first-time home buyer is spending $10,000 on an attorney and maybe, hardly ever getting a resolution, and they need to move on. They need to move out of the house.
As we're going through this and like you had the pros and cons list, and I took a picture of it, and some other slide you had, I took a picture of too, and part of me is like, gosh, maybe I should give this information up front to buyers and sellers so that they can do their homework if they want to. And then a part of me goes, oh my God, that would be totally going into the weeds. Yeah, and I would kick myself for after the first time of giving somebody, that information, and all of a sudden their, danger radar is up to here and they're thinking, oh my God,
I'm gonna buy a house.
Exactly.
I think you
It's too
do need to
scary.
feel, obviously in your initial buyer consultation, you don't know that personality yet.
Yeah.
But you do kind of have to feel that out a little bit. It doesn't hurt to include that in your buyer
True.
package.
And
Put
you
a
know-
copy of it in there.
Yeah.
Along the same lines, every time I go on a listing presentation, I give them a blank disclosure and say, whether you list with me or someone else, you're gonna have to fill this out, so start filling it out now and start thinking about it. You could also give the arbitration form at the time that you do the buyer consult and say, at the time you make an offer, you're gonna have to sign or decline this. If you're a research type of person, you should start researching it now.
And highlight the website. If you have further
Yeah,
questions,
yeah.
go here.
Yeah.
Same with the seller on the listing appointment.
Yeah.
And it'd be interesting to say, hey, this is something that's gonna come up. It's something that's worth researching for how you feel about it. Here's the
Yeah.
website, maybe.
And then maybe highlight at the bottom where it says, the residential real property arbitration agreement is a legally binding contract between buyer, sellers, or the part about if you desire legal advice, consult a lawyer. Don't come to me and,
I think the other piece on that though is at the very top of that is this is an optional
Yeah.
voluntary agreement.
Yeah.
Not all parties have to sign this,
Yeah.
where in the purchase agreement, all parties do have to sign off on everything. This is
Yeah.
the one piece you don't have to,
My brokerage requires it be written declined. If you decline it, then you don't have to sign it.
No.
Well, we covered a lot of good information. Thanks for the additional insights and really good questions. I think this is why we have a position, not a policy. We ran through it over and over and over again as an ALC. There are a lot of pros and cons, but when it boils down to it, something that you just can't give advice on, that your clients have to decide. Very good. Well, thanks, you guys. Happy
Thank you.
Monday.
Thank you.
Go back to Zoom and see if there were any questions on there. Thanks to those of you that are on Zoom right now. Do any of you have questions? I don't see anything in the chat box.
Thanks, Melissa.
Yeah, absolutely.
Thanks, Melissa.
You're welcome.